Welcome to another edition of the Trusted Advisor podcast and video series powered by the Retail Solutions Providers Association. Our goal on the pod is to accelerate the success of today's and tomorrow's leaders in the retail IT channel. I'm Jim Roddy, back with you again. Thank you so much for joining us. Today on the podcast, we have a return guest making her record 13th appearance on the Trusted Advisor is RSPA General Counsel, Attorney Jill Miller. Welcome back, Jill, and welcome to lucky episode number 13.
Terrific. Thank you so much for having me again, Jim. I appreciate it.
You betcha. Happy to do it. So for those who don't know Jill, she is a partner in Detroit-based law firm Bodman PLC. She serves as RSPA legal counsel since 2020, providing advice to all members, especially VARs and ISVs. And that advice is available at no extra charge to RSPA members through phone calls, emails, video chats, and in-person meetings at RSPA events. So Jill's been engaged in our industry for several years, counseling clients on subjects like data privacy, cybersecurity, card processing, mobile payments, ACH, electronic fund transfers, virtual currencies, and more. And her sessions on cash discounting, surcharging, dual pricing the past few years at Retail Now were big hits. And Jill, can I flatter you with one more comment from one of our members?
Of course, yes.
So this is from Tim Flockman of BPAWS. He said, as our company entered a growth phase, the volume of contracts became overwhelming, pulling focus from the core business. Partnering with attorney Jill Miller through RSPA's legal services gave us peace of mind with reduced risk and freed me from being buried in contract work. This not only saved countless hours, but also prevented costly mistakes, allowing me to focus on growth while sleeping better at night, knowing we had sound counsel. So RSPA will save you time and money, and we will help you sleep better at night if you work with Jill. So very nice to hear, Jill.
Oh, you know what? I've just had so many members. I remember meeting Tim in person at Retail Now when we were in Paris. We had talked on the phone and sort of seen each other, but it's just wonderful to be able to go to the events and then meet people and sort of deepen the relationship and the knowledge about their business. And it's just a great group of people we have here at the RSPA. The members are amazing.
Amen. 100% everything you said there. So, all right, well, let's get to the meat of our conversation. What we're going to talk about today is the concept of legal interpretation. And so we want to have that conversation today because some RSPA members hear you say on stage at those events, my interpretation, and they might think it's just you giving your personal interpretation, but it's a legal interpretation, which is different. So for the business leaders in our audience, can you explain the difference between your legal interpretation and like my personal opinion or interpretation? And why is that important for those business leaders to understand the difference?
Well, I think, first of all, right, as a lawyer, we have sort of an obligation to provide advice and input on matters that require research, that require expertise, years of sort of doing things, knowing where to find information about a particular topic. And so when I get on stage and talk about credit card surcharging, dual pricing, cash discounting, I think a lot of people want me to say, this is absolutely, positively the way that these rules are interpreted or these laws are interpreted. And, they might have a conversation with a member over coffee, and that member might say, well, in my opinion, this is the way that, cash discounting works. And then I'm on the stage saying, in my opinion, this is, my interpretation of a particular rule or law. And the issue is that it's not black and white, right? I mean, I loved my undergrads in accounting and I loved it, right? Because, you have debits and credits, and at the end of the day, everything, tallies out to zero and you move on. But in the law and in the interpretation of rules and statutes and case law and all the other sort of resources we use to provide input to our clients is, all of that together is really what supports when I make a statement on the stage. And unfortunately, when we're interpreting the card brand rules, for example, there are, there's not this, 10-page sort of dissertation of what all the different situations that can occur when it comes to a surcharge. And furthermore, the card brand rules don't talk about dual pricing. They make one mention of it in a frequently asked question document, but and actually it's referred to as actually a cash discount, but it says you can either price for a cash discount, you can either list the card price or both prices. So, when I'm up there, I'm trying to provide to the group a reasoned, educated, researched analysis of the rules and the state laws and the federal laws to the best of my ability. It's not, I think that you should do, it seems reasonable, right? I mean, so
give it a shot. Yeah, see how it goes. Yeah.
Right. And so, as a lawyer, I am conservative because I want to be sure that, I can point out the things that could go wrong, and or how maybe it could be interpreted differently by a card organization or a state. So it's really about a thoroughly researched and review of all the materials that are available about a particular topic. So I think that's it in a nutshell, sort of what varies between my interpretation and having coffee with someone who might have actually, done as much research as I have. I am a trained lawyer. I've been practicing for 20 years. I feel confident in my ability to leave no stone unturned. And sometimes, people find an answer and think that's good enough for me and don't realize what they don't know.
Yes. Yes. And like you said, there's gray areas. And if you look, there's some in law that is just black and white, right? Like it's settled case law, there's all sorts. But we talk about surcharging and, cash discount, dual pricing, all that kind of stuff. That's in the grand scheme of things relatively new. And even just electronic payments is still relatively new in the grand scheme of, right? Like it wasn't written in the 10 Commandments, right? It's a fairly recent thing. And so is that part of it as well? Is it's an element of, hey, the question you're asking me, there might be some nuances to your exact situation, and I don't have like 50 examples of settled case law to be able to refer to, and that's what makes it more open to interpretation, not just by you, but also like a judge who might be ruling on it or some regulatory body. Is that an element of this as well? There's so many things stacked up that make it gray, that's kind of the world that we live in. And so you can give people some guidance, but it's way less frequent that something is settled case law in the electronic payments world. Is that a fair way to put it?
Absolutely. I mean, we know it wasn't until 2013 that the card brands finally came out and based on a settlement, right? That they were forced to permit surcharging. And then the state laws, those have been evolving and changing over the last 12 years. So it's really, Visa doesn't publicly announce the analysis that they go through for a particular merchant who gets fined, who's maybe not, complying accurately. So yes, it is definitely something that we don't have a wide body of information to review. And so we're just trying to take whatever Visa, really is the sort of the leader here in providing from the card brand perspective, the information, and then following state laws as those evolve throughout the, past decade.
And actually looking at the law, not here's the best of my recollection to it, right? You want to be able to review the law and compare the examples. So thank you for that. So can you also discuss the nuances of an attorney like yourself offering a legal interpretation versus telling clients exactly what to do. I know that's how sometimes folks look to their legal counsel, right? You and I meet on a regular basis, but I guess I understand from being around long enough, you don't just say to your attorney, "What should I do?" And then you go and write it down and go, "Okay, like that's what my attorney
Right.
told me to do." You don't like, shut off your brain or wash your hands of it. Can you talk about again those legal nuances in that context?
Yes. Well, I mean, my job is to advise, and the client's, job is to decide. And so I find that my best work and the best outcomes come when I am in conversation with my clients, right? And talking to them about, here are the things that, from a legal perspective, right, that I believe to be true. But now let's look at the contract and you tell me about what happens in real life, right? Why is it that I'm just going to make something up. Why is it that you say you want a 3-year term and I've got a 5-year term, right? And so these are things that, the client might say, well, I have found in my past, 20 years of experience or 5 years, that every time I submit this agreement to a contracting party, they always change it, and so to me, if it has an auto renewal, that's fine. So it's really about me arming my client with all the information that I can provide about a particular topic, and then them making the decision, because ultimately the risk, financial, reputation, everything else, lies with them, and they have to deal with whatever consequences result from. And entrepreneurs, right? They're fine making taking risks, right? That's sort of what separates them from me, right? I am a
Hmm.
lawyer who really is risk averse, my personality. And so, but over the years, I've gotten comfortable with clients that are like, absolutely, I'm doing this. I'm going for it. I understand what you're telling me. And I'm like, okay, let's just have one more conversation. I want to make sure you fully understand. And then they'll say, yes, I fully understand. And this is what I'm doing. And I'm like, okay, great.
And tell me if there's somebody, so thank you for that. Somebody gave me this analogy one time, and this is kind of how I've thought about it. If you're driving, like the business owner is in the driver's seat in a literal car, they're pulling out into traffic. You know how sometimes you'll ask your passenger, "Hey, can you look to the right for me and tell
Right.
me what it is?" If you pull out into traffic and you go and hit somebody, and the police officer, you can't say to them like, "Well, but the passenger told me the coast was
Right.
clear." The cop would say, "You are in the driver's seat. You are responsible for pulling out." Is that kind of how it works as well in terms of, again, when you're giving advice, but you're the passenger, you're only giving advice, that person has to make the business leader, they're the driver, they're the ones who's making the decision. Is that accurate?
That's accurate. And as a lawyer, it's really important that you're giving accurate advice, right? That you are giving, reasoned, substantiated input that, the businesses as your the decision maker can rely on for their business. When I'm driving, my husband's always like, "Okay, my side," and I'm like, "I don't want to hear 'Okay, my side.'" Again, risk averse, right? I want to look myself, and I think that's why a lot of our members do engage with lawyers, because it's another perspective. It's a reasoned and a uh, substantiated input that then they can make, the best decision for their business.
And to take that analogy one step further, in terms of you have to have somebody who's trusted and somebody has a really good view. You and I are both originally from up north in the United
Yes.
States, and we know in the winter you can't just look through the ice, right? You've got to roll down your windows sometimes, even though it might be 10
Yes.
degrees, to get a really good view in terms of what
Yes.
you're seeing there. So I'm sure that analogy will break down somewhere, but it helps stick in my mind in terms of my responsibility as a business leader when I'm getting accounting advice or legal advice or something like that. You got to run it through the filter and you can't abdicate your decision making.
Yes. And I feel oftentimes that I'm a Debbie Downer, that I'm always like, oh man, like this could happen. This is bad, right? Think about this, think about that. And but again, it's just because I want to make sure that they know all the potential pitfalls of making a decision. So,
Very much. Very good. Well, I have one more question for you, Jill, but first we're going to pause here to let our listeners and viewers know about the Retail Solution Providers Association. The RSPA is North America's largest community of retail technology VARs, software providers, vendors, and distributors. To accelerate your growth through an RSPA membership, email membership@gorspa.org. Also, we want to say thanks to these companies who support the RSPA community and make this podcast and video series possible. Our platinum sponsors, Blue Star. Our gold sponsors are CoCard, Epson, Heartland, and ScanSource. And then finally, registration is open for Inspire 2026, the Retail IT Channel's premier leadership conference. RSPA Inspire is set for February 1st through 4th on the island of Kauai, Hawaii. For more information, visit gorspa.org/inspire so you can experience networking nirvana, and you can hang out with Jill for a few
yes,
days as well and pick her brain.
yes.
So Jill, every time you and I talk, I always want to bring up the topic of surcharging, cash discounting, dual pricing, and everything under
Mhm.
that umbrella. I was just at a conference last week, and that's something that was discussed on a frequent basis. So, what's the latest you've been hearing about, again, surcharging, cash discounting, dual pricing?
Well, first of all, in October of 2025, Visa put out new rules, 900 and some pages if you feel the need to take a perusal of them. But, a couple of things that I noticed, it didn't seem that the surcharge language had been changed, but I haven't taken a deep dive. However, I did note that there are two schedules in there that talk about violations and fines associated with them. So there's a significant violation schedule that talks about the fines that a merchant, or, ultimately it's, the merchant gets fined, or the acquirer gets fined and the merchant gets fined, and they've got to sort of sort it out. And then also repeated violation schedule with various levels of fines if you're found, if a merchant or an ISO who's, encouraging a merchant to not run a compliant surcharge program. So, they're setting out exactly what those fines are, and they're not going away. I mean, I'm still seeing and hearing from ISOs that their merchants aren't listening, and, we've tried to provide them with training, and then they continue to, not comply with the rules. So again, it's not going away. And, another thing that I talked about, I think at the Retail Now, was about this California and Minnesota drip pricing laws. And again, people have said to me, come to me and said, well, I know I can't surcharge in California, and that's incorrect. You can surcharge underneath this law because it's not an automatic fee, because a consumer can change their payment method and not incur the fee. So, again, I think that's another instance where there's this big law and people might Google surcharging and they might come up with something that says no surcharging in California. Well, that's not true. So, it's really important to dig deep and really understand what the law actually says about, and there's Attorney General pages for both those states that talk in detail about this. So it's not just the law. Again, there's other sort of supporting evidence about that a surcharge is permitted.
That's great. And that makes me think of a couple things that you bring that up. One is you always remind folks to go, like you mentioned, the Visa 900-page document. Go to the original sources, not secondhand sources or rumors or here's, what I
Right.
heard or something like that. And it also makes me think, tying in with our first subject, there are times where people are asking you questions and they say, yeah, but this other guy doesn't, and he hasn't been caught yet, so that means it's okay. And you're saying,
Right.
I'm just telling you what the law is saying, and my legal interpretation is what that person is doing, that just means they haven't been caught yet. I guess, is that
Yes.
fair to say as well?
Yes.
That's oftentimes what comes up.
I've had people chase me around. When I first started representing the RSPA, I had a couple of people chase me around the trade show floor trying to convince me that their program was compliant. And I just kept saying, unless you can show me something else, what I'm looking at here on its face is that that is not compliant. So again, sometimes people don't want to hear the interpretation also.
Sure. And I'm friends with a psychotherapist, and so she didn't share any specific information with me, but she says there's a human condition where people say, hey, here's what happened. I'm in the right. Right? Like they're looking for their therapist to say, yes, you're darn right. And
Mm-hmm.
sometimes a therapist says, here's how you might be contributing to it. And some people just don't want to hear that, right?
Right.
Human beings want affirmation for the most part. You're not paid to give affirmation.
Right. I would say though that a majority of our members are open-minded, are interested in hearing about, various programs and ways that people are doing it. And I do believe that, our members and, the community is creative, right? That's what entrepreneurs are and salespeople. They are creative and they can find solutions, right, to problems that maybe I haven't thought of. So when those are presented to me, again, most people are open-minded and eager to hear a legal perspective on a particular program they're running.
Yep. And the conference I was at last week that talked about, again, the whole, dual pricing thing, they talked about this has been reviewed, this is in line, it meets all the standards, and that is step number one. Like, just don't get hypnotized by all the potential revenue. So Jill,
Right.
finally, how can RSPA members connect with you to discuss any legal issues?
Well, they can email me at jmiller@bodmanlaw.com, or they can call my office at 734-930-2499. And I would be happy to set up a chat, a phone call, a Zoom, whatever works. Or again, I'll be at Inspire and I'll be at Retail Now next summer. So always eager to meet our members and provide any assistance that they think might be helpful for them in their business.
Very good. And also the email for all your RSPA needs. If you email membership@gorspa.org, we'll connect you with any one of our services, including a direct connection to Jill. So, well, that does it for this episode of The Trusted Advisor. If you enjoyed our discussion, please be sure to subscribe to the RSPA YouTube channel and the Trusted Advisor podcast so you never miss an episode. Before we go, big thanks again to Jill Miller for sharing her wisdom with us today. Thanks also to RSPA Marketing Director Chris Arnold for his production work, Joseph McDade for our music, and last but not least, thanks so much to you for listening. Our goal at the RSPA is to accelerate the success of our members in the retail technology ecosystem by providing knowledge and connections. For more information, please visit our website at gorspa.org. Thanks for listening, and goodbye, everybody.